All right. So everybody here and audible?
Yes, sir.
Okay, we got Mike. What about Alyssa? Can you hear? I don't think she can hear.
She's on mute.
Oh, I gotcha. Hold on one second. Okay, there we go. Oh, is that your pen?
Mm-hmm.
That looks like my pen. It's all chewed up. All right, cool. There we go. So I guess we lost her, huh?
I think so.
Oh, well, that's too bad. Anyway, how's everybody doing?
Good. How are you guys?
Good. Good. So, who wants to start first? What questions, what issues, what concerns, what do we have going on?
As always, ladies first.
You can go first, Mike.
Hey, I just wanted to check in with you guys. I know I've been away for a few weeks. My question today for you is, can you give some tips and pointers on how to effectively tell your storyline without boring your reader or putting too much on them or
Yeah.
irrelevant, pointless, facts or events in the
Yeah,
case?
in the story, right, right. That's a common problem, not just with pro se litigants, but with attorneys too. And sometimes, even in our complaints here at this office, there's like a fine line between too much and not enough, right? And just through experience, I've found that even though the federal rules of civil procedure require you to provide a short, concise, and plain statement of the facts that support your claim, that's the language of the statute. Short, concise, plain statement. What I've found is that federal courts are very different from state courts in their view of how much, what quantum of facts are adequate to support each claim. And frequently it'll depend on the judge, the type of claim that you're, pressing, and even defense counsel on how they approach your lawsuit in their motion to dismiss. So what I've found in mine is that it's always better to err on the side of a little bit, not too much, but a little bit more than you think is probably necessary. Now, one thing that people do is they have a tendency to put in a lot of minutia, little things that, just don't matter, events leading up to the main event that really in the grand scheme of things don't make any difference in the liability determination. And what that does, the impact it has, it's a very negative impact, because what happens if we remember that, the reader, usually a judge or a law clerk, they have limited bandwidth to absorb all the information that you're throwing at them, right? And if you burn up that limited bandwidth on things that don't directly relate to the claims for relief that you're pressing, then there's a high probability that the motion to dismiss or motion to strike, whatever it is going to be granted. So what you want to do is, the first thing you want to do is be familiar with the law that you're going to rely on to support your claim for relief. Because remember, all your claim for relief is an application of your facts, your relevant facts, to the relevant law that applies to your circumstance. So how do you go about figuring out what facts are, relevant to the claim that you're pressing? You have to read the cases. You've got to actually go to the case law, find cases that, are on all fours or close to on all fours with your situation, and read those cases and figure out, okay, well, what did they plead to make it? What are the essential elements of that type of claim that I need to lay out in my story in order to support the claim? Well, one thing we have on Patreon that is going to shortcut it so that you don't have to go out and read hundreds of cases to develop an instinct about how to tell your story is I published, I don't know when it was now, it's 2018, 2019, something like that. I did a continuing legal education course for attorneys out in Arizona at Arizona State University Law School in downtown Phoenix. As part of that program, I put together a substantial PowerPoint presentation. I don't remember how many slides, like 100 slides maybe. And in that, I outlined the various types of claims for relief, the conduct that you would generally go after, and then provided not only the cases that support each various type of claim, but also sort of short summaries about what you're looking for, what you need to show in order to make your claim stick. So that would be a good starting point. That'd be a good point of first departure for your research in figuring out what facts are going to be relevant to your story. Once you have that, once you have the legal framework, then it gets sort of easy to tell your story, because you know that you're going to have some common elements that are essential. Like on a warrantless seizure case, we know that there's going to be a kid. We know there's going to be a referral that gets called in, and we know there's going to be an ensuing investigation. So those are things you can tell in your story right away, is that, I have a kid, he's X number of years old, something happened that triggered the referral was made, an investigation ensued. Then you can go into what happened in that investigation. Well, they didn't interview anybody. They came out to the home was clean and tidy, there was plenty of food in the cabinets, there were no apparent dangers. They checked the child for bumps and bruises, there were none. The child was in generally good health and happy. There were no apparent dangers at all whatsoever, right? So that's your story leading up to what we know now is going to be an unwarranted seizure, right? So then you just sort of bleed into what happened next. Okay, well, the social worker started asking questions, and I got, or mom got, or the parent got incensed, slammed the door in her face and said, get your ass off my property, right? Well, that didn't sit well with the social worker, right? So she went in without a warrant, grabbed the kid, even though there was no exigent circumstance. The child was healthy, happy, well cared for, right? So that's your basic storyline for an unwarranted seizure. And surprisingly, just with those facts, it's not far off from the way it really happens. So I think that might have answered your question.
Yeah, definitely. So just to piggyback off that, I have a bunch of your PowerPoint slides screenshotted. So if we're utilizing some of these points, it's a good practice to go actually read the cases that you listed that correlate and validate the claim that you're making. Like, for example, the after acquired evidence cannot support claims of exigency. Right. And then you have some Jones versus County. You would recommend going to, skim through and read how they presented that case. Okay.
Right. I'll tell you the reason, because what's going to happen is the more cases you read, the more you'll develop kind of an instinct for what facts are going to be meaningful for your particular situation. Because, obviously not all facts need to be, stated. It's like you don't have to go in and say it was a Tuesday morning, raining, the rain stopped, the clouds parted, the sun shone through, and then the social worker knocked on my door. You don't need that level of detail, right? So, to sort of keep that in mind as you're putting together your story.
Thank you.
Do you have anything further on that question or that issue? Seems like she's having trouble staying connected. We have somebody else just sent me an email trying to get in. It says, are the instructions to click the connect button next to Discord under app integrations? I have no idea.
I think he's talking about when you come in off of
Off Patreon, I think.
yeah.
Yeah, I don't. Do you guys know the answer to that question? I can email her back and tell her.
I think as long as he has his Discord already set up, it'll link to it'll jump to his profile when he hits that connect
Okay.
using the same email.
Yeah, what I do is I just go directly to discord.com and then I click on the cat and then I click office hours and here's where you guys are.
All right. So, but you've already set up the Discord. So how would a person do it who's? Oh, there she is. She's back. Seems like you're struggling a little bit. Maybe poor internet connection. Also, you're muted. I don't know if she can hear us even. I know. That's all right. But
Let me ask a follow-up question real quick on the topic we were talking about. I noticed that you like to put little blurbs to kind of grab the reader's attention, and then you kind of get into that. How did you go about grabbing those particular blurbs? Did you kind of just, because you followed along from beginning to end, you kind of knew where the, pressure points were, or is there a
do you mean the headings in the general fact section will have like
Yeah.
headings?
Yeah, occasionally you'll throw in a heading, kind of describing what's coming up, mom and, dad met, and, so on and so on.
Yeah. Okay, I know what you're looking at. I do that for two reasons. One, we don't really have chapters. They're typically not that long of a story, but there are phases in the story, and some of them are going to be relevant to the claim. Some are not directly relevant to the claims. Like, for example, typically the first heading, or first chapter will be, mom and dad met, got married, had a baby, right? So that's just sort of a signpost for me as I'm writing it, because we do have a structure. There's going to be a beginning, there's going to be a foreshadowing up to what's going to happen, then there's going to be the event, right? And then there's going to be a conclusion. So I use, just for my own purposes, I use those headings just to kind of remind me what stage in the story writing process I'm at, right? And those are going to vary depending on what type of case you have, or if you have several different components. Like if you have a warrantless seizure, a warrantless medical exam, and a. Are you guys hearing feedback? I wonder if I put in a headset.
Yeah, I hear that echo.
Yeah, hold on a second. Let me put on a headset and see if that goes away. All right, can you guys hear me? Somebody say something.
Yeah.
Testing.
Yeah, that
1, 2,
sounds.
1, 2.
I think that sounds better. Are you guys still hearing feedback?
No.
Huh, that's weird. Could be lag on my end.
I think you're good now.
Yeah, that sounded better. All right. Anyway, cool. What was I saying? I was saying. Yeah. That the headings may vary depending on what claims you're asserting in your case. For example, if you're just a warrantless seizure claim, then your headings are really just going to relate to that claim. You had a kid, there was a call or some event that spurred a call, that triggered an investigation, a worker came out, blah, 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 blah. Then you get through the events, right?
Right.
But if you're going to have an unwarranted seizure and judicial deception and maybe a medical exam, unwarranted medical exam, then you're going to have section headings in your story for each of those categories of events, right? Because what you want to be able to do when you, more or less, this is for when you're doing your opposition to their motion to dismiss, you want to be able to just very quickly go back and say, okay, here's the section heading that's going to have all the facts that relate to the medical exam, the unwarranted medical exam. So in your opposition, your motion to dismiss, then you can just say, go see this section in the complaint, right? It makes it really simple to write up your factual statements in opposition to the motion to dismiss. Does that make sense?
Definitely.
And I'm not sure I answered your question because I kind of got.
Yeah, yeah. You hit it right on the head with chapters. That was a good way of kind of breaking it down. Is there's no real chapters, but there are events. Main primary events that have probably sub events. But as long as you have those chapters in there, so to speak, it'll keep you on your timeline.
Yeah. Also, it'll keep you on track, and it keeps the reader focused too. I mean, that's just been my experience. As you go through, you say, "Oh, okay, here's the headline. So this is what we're going to be talking about."
I have a question. Sorry, my mic wasn't working.
Yeah, no problem.
For a while, I was having some major difficulties. So with the warrantless seizure, when they take the kids and they don't have a warrant, and they have a certain time frame before they have to go and file for emergency protection, correct?
Well, where are you located? Because in
Montana.
Okay, because the way it works in California, and I think Montana's, you guys are Ninth Circuit anyway, so the law is going to be the federal law is going to be more or less the same. The way it works when we're talking about procedural due process, there's two different types of due process, right? There's pre-deprivation due process, and then there's post-deprivation due process. You're entitled to both. So what that means in terms of seizing a child without a warrant is unless there is an emergency, an emergent circumstance, imminent danger, like an axe is falling and the social worker has to do something right away to save the child. Unless there's that sort of circumstance, they have to give you that pre-deprivation due process. That means they have to go in front of a judge or magistrate, swear out an affidavit, and get a warrant in order to lawfully take your child, at least lawfully under the 14th Amendment for you, 4th Amendment for the kid. So that's the basic rule on pre-deprivation due process. Now, I know that some states, they don't really account for, in their enabling legislation, they don't really account for this concept of pre-deprivation due process, but they do give you post-deprivation due process, meaning they'll take your kid, and then within 72 hours or something, they go get a court order to keep your kid. Well, at least in the Ninth Circuit, if you're in other circuits, like East Coast or Texas, 2nd, 5th, who else? 3rd, I think 4th, they all sort of hook up on this idea that post-deprivation due process is good enough. Luckily for you, you're in Montana, you're in the Ninth Circuit, and the Ninth Circuit's pretty clear on this, that it doesn't matter if you have some 72-hour hearing after the fact. If there's no emergency, you can't take the kid without a warrant. So the fact that you're in Montana is a good thing, because it means that if there truly was no imminent danger, then they had to go get a warrant.
Okay, so what if they don't get one at all? So in my situation, or in a situation where they come to your house and they say that the kids are fine and that they're going to close the report, and then they leave the kids there and tell you that you need to go get a drug test. So you go get this drug test done, and then they tell you that your drug test was positive, and you say that that's not accurate and that you want to retake the test. Well, they don't do that. They tell you that you have within the hour to have your kids down at the department, or they're going to be arrested. A police officer and the worker is going to come to your house and arrest you, potentially in front of children, if you don't bring them to them. So you bring them to them, and they tell you that there is no other option. You have to call your mother. Your mom's going to take them, and they're not coming back with you. That there's no agreement as to, like, I'm not voluntarily saying that I want to do this. You're telling me they have to, or I'm going to be arrested. Well, I don't get a hearing or nothing.
You're running into a couple different issues there. One is coercion, right? Coerced consent is really not consent at all. And again, in the Ninth Circuit, you cannot coerce consent. So if they're saying consent to, giving up your kids or we're going to arrest you, then your consent's vitiated, right? It's not real. It's under threat of arrest. So that's the first issue, and you would treat that analytically. You would treat that as if it were a warrantless seizure. Okay. Secondarily, when you're looking at placing the children with your mother, let's say, at least temporarily during the conduct of the investigation, that gets into a situation of lesser intrusive alternative means, just analytically. Because remember, the rule on unwarranted seizures by social workers, anyway, in the Ninth Circuit is pretty straightforward. I don't know if you've been watching the deposition videos or any of that stuff, but if you have been, by now you should have it committed to memory. And it's pretty simple and straightforward. The social worker, government social worker, cannot lawfully seize a child from the custody of its parents unless at the time of the seizure that worker is in possession of specific and articulable facts to show that the child's in immediate danger of suffering severe bodily injury or death in the time it would take to get a warrant. And remember, it's a two-part test, right? And there is no lesser intrusive alternative means of averting the injury, other than just outright seizure. So that's what you're talking about. That part of the test is what you're talking about when you start talking about, placing the child with a relative, with your mother. That would be, if there truly were a danger, and that's kind of where the rub is going to come in the factual scenario that you just laid out, is if there truly is a danger to the child, then we have to look at lesser intrusive alternative means of ameliorating that danger. And one lesser intrusive alternative means would be to either remove the parent who they perceive to be the danger, or remove the child to a relative or some other safe place, at least on a temporary basis. So if that conduct then were reasonable under the circumstances, they're not going to be guilty. But that reasonableness, that will be a jury question. Was it reasonable for them to, remove the kids and, place them with a grandparent or whatever under the circumstances presented? That reasonableness inquiry is always going to be a factual question for a jury. The deeper question, I think, in your situation is going to be whether or not a positive drug test, just standing alone,
And a disputed one that it wasn't accurate.
Well, that may be true, but you have to understand that the social workers are going to be entitled to rely on whatever some third-party lab tells them. So from the perspective of the court, when you're pressing one of these claims, or the perspective of a jury, if you get that far on it, the social worker is going to be entitled to rely on the veracity of the test results that are provided by a third party or the third party lab. So you have to assume, okay, fine, we got these positive drug test results, but that standing alone is not sufficient to show that the children are in immediate danger of suffering severe bodily injury or death in the 2 hours it would take to get a warrant, right? So let's just assume for the moment, yeah, you had a positive drug test. Okay.
There was only one.
Well, let's just assume you had a positive drug test. So what if it's only one? Maybe even there were 2 or 3. Who cares? Were you so impaired that your children were in danger, immediate danger, such that, the warrant requirements were obviated? So analytically, that's going to be the question. And I don't know. I mean, you'd have to do some research, because just nothing pops into my head in the Ninth Circuit addressing that question. In California, under California law, there is a case. It's a published decision out of the, 4th District, 2nd Division, I think, that says essentially that drug use is not the same as drug abuse. And even if there is drug abuse, there has to be a showing that the drug abuse was so substantial that it severely impaired the parents' ability to care for, protect, and provide for the children. But that's
That's
just California state law. That I don't know that there's.
I think Montana's relatively the same
Okay.
as that. Yeah.
Yeah. So that's what you would want to look at. So anyway, I think that answered your question.
Yes, it did. Yes, very much.
Okay.
Thank you.
So it looks like we have two other people. Looks like Aaron Carranza. Are you there?
Hi guys.
Hey, how's it going? Did you have any questions, issues, anything?
I did, but I'm currently stuck in Ohio on a case, and I forgot my notes there. But
Oops.
just a general question. When one parent takes another kid, they're not considering it parental kidnapping anymore. Do you know just generally what you would file to bring it to the court's attention beside an order to show cause motion?
No idea. I have no idea how
Well, what are you
to
doing?
address something like that. I mean, if somebody else has a clue how to deal with it, just chip right in. But yeah, I don't know.
So we came to Ohio
Aaron,
to...
I can't hear on my side.
You can't hear me?
I can't
Hello?
hear.
Marissa, you there?
I'm here.
You can't hear me?
I just can't hear Aaron. I can
That's
hear
weird.
Elisa, I can
Oh,
hear
that's
Mike.
Weird.
I just can't hear Aaron.
My mic is on. It's weird.
I can hear you.
So yeah, no, we came to pick up her daughter, and the dad won't let the daughter leave. So we called the police to enforce the custody
Mhm.
order. Of course, they didn't, and now she has to file something in court. And I'm not an attorney, so I don't know how to.
Sounds like that'd be in family law court, right?
Yeah. I mean, he already has. I already did the order to show cause motion. I filled out the paperwork for her and all that stuff in Pomona, but she didn't think that she wasn't going to get her kid back because it was the end of his vacation time. So
Yeah, I don't.
I'm just trying to preempt any kind of.
I don't know what to tell you on that. If you have a custody order, you should be able to just tender it to the police and have them enforce it. If
Yeah,
they
wouldn't do
won't,
it.
then you need to just go into court and file an ex
That's what I
parte
figured.
act.
I just didn't know if there was any like little tricks or anything that you knew. I'm doing it the
No.
basic way, but just didn't know if there was any easier. If
Maybe
you knew
could try to
anything.
file an emergency ex parte.
Yeah, that's tomorrow morning.
Determine. Okay.
Yeah.
Determine some type of immediate harm or.
Yeah,
danger
so
to
that's
the
tomorrow
Hey,
morning.
hey, Aaron, this is
Sorry.
sort of like radio
I
communication.
know. I just got sidetracked. Sorry,
Yeah.
I won't.
Well, no, you just gotta wait. Whoever's talking, you gotta wait till they're not talking anymore. Otherwise, you talk over each other and nobody can hear anything.
I think the problem is that Mike, me, and Elisa can't hear Aaron.
Yeah, I can't hear anything.
I can hear Aaron.
Oh,
I can't.
That's so weird.
Did you guys mute him?
Say it again, Mike.
Did you guys mute him like in office hours? If there's like a slash mic next to him, you might have muted him because you could turn other people's off
Oh,
if you
really?
want it. So you might want to go check your settings and make sure you didn't mistakenly mute anybody.
Is that on my side or everybody?
Anybody's side.
Oh, wow.
Just like by their name.
Yeah, you should be able. Let me go back to where I found it.
Oh, that's interesting. How do I do this? How do I get back? Oh,
James.
oh, what the hell here? Yeah, well, James is off at volleyball, man. So I can't, there we
If
go.
you right click, let me see if it does it on everybody.
Right click.
Yeah, if you right click their names, it'll have like a mute checkbox. Make sure that's not checked.
Oh, I see what you're saying. So you actually right click on the video for the person and it'll come up with a whole big long list of different things.
Wait,
Yeah.
so you can mute yourself for other people not to hear you in a conversation?
Well, I can
Let's
mute
mute
any
here.
of you.
Go ahead.
Mute soundboard. What's that?
Aaron, can you hear me?
I-
Yes, I can hear you.
that a yes?
Yes.
Okay. I was just testing it out to see if it's two way or
Marissa's
one
still
way.
talking because I just muted her. So if she was talking, I couldn't hear her.
Who did you mute?
Marissa?
No, I can't hear. I can hear you, but I can't hear. Still can't hear Aaron.
How
So-
interesting.
Settings.
I'm not sure.
Well, this is a learning experience for all of us then, I guess.
I
Every week.
thought I was just old. I couldn't figure out how to use it.
Well, let's see if there's so this is right. Oh my god, there's like so many different things that you can do here. So, Aaron, anything else on that subject while we're here? I'm not a family law attorney, so I really don't have any advice on that for you.
I know. I just was trying to preempt if anything and be ahead of the other parent, so I was gathering as much information as I could. That's all.
Yeah, no, I get it. Marissa, you have any questions, issues?
Yeah, I have a question. So I requested in my case to have to defer time on the IFP review. That one was granted. So I'm very confident that I am going to be filing a Fifth Amendment complaint. But my question is, do I necessarily need to add in the factual allegations that happened after the detention hearing at this point, considering I'm still not at my 2-year mark for everything that happened afterwards? Or sorry, not detention, the disposition hearing.
Well, what happened after disposition that you think gives you a claim for relief?
Continued judicial deception and retaliation.
I think what I would do on that is I would state all facts to support all claims that are ripe right now, regardless of when the statute of limitations runs. So if you
Got it.
so if you have a ripe retaliation claim, you know what I mean by ripe, right?
Yes.
That means that, if there's 4 elements to a claim, let's use negligence as an example. The elements to a negligent claim are duty, breach, causation, and damages. The claim is ripe when you have facts to support all 4 of those elements. Does that make sense?
Yes.
So if you have facts to support all elements of your retaliation complaint or claim right now, it's ripe and you should assert it.
Okay.
Because you have to remember there's another, might even be statutory. I'd have to look to be able to give you the FRCP rule, but essentially there's this idea that all claims that are arising from the same sort of continuum of events are compulsory in nature, meaning that you have to plead them if they exist. If they're ripe, you have to plead them at the time that you plead your complaint. So even if your statute of limitations has not yet run on some of your claims, if they're ripe, they're compulsory. You need to plead them.
Got it. That makes sense. I'm following.
Yeah. Does that make sense to everybody else?
I have a question about that.
Yeah.
So, what if you
I have a question.
just found out
another quick
about it?
question about
Hold on,
I
Alyssa.
can't hear.
I don't think you could hear Aaron, but Aaron had a question. So,
Aaron-
just-
Oh, sorry, Aaron.
It's okay. It's okay.
so Aaron, can you ask that question again slowly, and I will repeat it
Yes.
to make sure everybody hears it.
Is it from the time that the bad deed happened or the time that you found out about the bad deed?
That depends. If you would not have known about whatever the offensive conduct was, like, for example, we have a case right now where, for example, the child was essentially murdered by the group home care provider. Well, that was suppressed. It wasn't in the court records. Nobody at social services told mom about it. She went on 10 years later down the road. Evidence comes out. She discovers it. Says, "Holy fuck! What the hell?" that's something that would fall within the ambit of what's called the delayed discovery rule, right? The county sort of took some subversive measures to prevent mom from discovering that her kid had been murdered. It never really came to light until much later. So you would have a good argument that the statute of limitations was told during that period of non-discovery. It's basically delayed discovery. So
Okay.
that's a pretty narrow circumstance. It's generally pretty hard to make that stick.
What if it was my husband or an ex-husband sleeping with a social worker, and that's why they took away Lola, was to please my ex-husband? I have proof of them having an affair.
Well, when did you discover it?
Probably 6 months before my case was dismissed. So like a year ago.
Well, if it was a year ago, then that would be within your 2-year statute, right?
Right, well, because I filed already, but I didn't file about that. I filed of other things, and so I didn't know if that was something else that is suable for, or how would I hold them accountable for?
Well, it probably is. I mean, the argument would be that, again, it's a violation of your 14th Amendment rights to take your kid without legal justification, right? Or to lie about the circumstances, to get an order to take your kid. And if the underlying motivation for lying about it was the fact that she's sleeping with the dad, it seems like that would be a claim. I'm not sure exactly what the claim would be, but it seems just as a matter of instinct that would be a claim.
Right. No warrant or anything.
Yeah.
They just
So it sounds like you would have a reasonable basis to assert, the delayed discovery rule.
okay.
But I would just try it, see what the judge does with it. But that's the issue you're going to want to do your research on, is delayed discovery.
Right. That was my next question. So that is the thing.
Right.
I'm the type of person, I will try anything and see what sticks. So I'm.
There's
I don't care.
there's nothing wrong with that. Alyssa,
All right. Awesome.
your question, you're next.
So it's with prosecutorial immunity, and so in the time before they go get a warrant, after they do the emergency removal, and does that qualify for that? They didn't go get a warrant?
What do you mean? There's no prosecutorial immunity for non-prosecutorial conduct, right?
Yeah,
So
that's what I thought.
So when they're grabbing your kid without getting a warrant, the decision to grab the kid, the decision to not first seek a warrant, that's not prosecutorial in nature, right? They don't need an attorney to seek a warrant. They do it the same way cops do. They just swear out an affidavit, go to a judge, say, here you go. There's nothing prosecutorial about that.
I just wanted to. I wanted to make sure that, because that's what they're saying. They're saying that they are entitled to it. So
no, that doesn't even make any sense. Do they cite some case authority to support that proposition?
they did. I don't have it out right now, and I can't get my monitor to work. But they did.
So where are you in this process? I presume that you filed a complaint, and that they filed a motion to dismiss.
Yes, they filed the motion to dismiss, and for failure to state a claim. And in that motion to dismiss, they've stated that they were entitled to immunity for that, or the removal of the kids.
For qualified immunity?
No, they said prosecutorial.
That doesn't make any sense at all.
It doesn't. Maybe they just don't know. You would think that they would.
Yeah, well, no, they may not know. If there's not a lot of 4th and 14th Amendment litigation going on in your area, then they may just be throwing a bunch of shit on the wall to see what sticks. I don't know off the top of my head whether we have anything up on Patreon that would address prosecutorial immunity in that context. So what you might do is you might take a look at Beltran versus County of Santa Clara. That dealt with prosecutorial immunity in the context of lying in a warrant affidavit. and in there you may see some discussion about the circumstances under which prosecutorial immunity would apply and in the converse would not apply. You also might go ahead.
I read over that same case that you just, the Beltran, and it doesn't. Because they're not their investigation at that point, because they took the kids and then they didn't even petition the court for emergency hearing or anything to say that it was emergency circumstances. I waited and said that I had agreed to it, which I had not. I was threatened that if I didn't, I would be arrested.
Yeah.
Didn't have any evidence, nothing to support why they were taking them in the first place. And then they didn't. She filed her affidavit. It was dated for, I believe it was December 10th, but she didn't file it with the courts until December 18th, 8 days later.
Huh. Okay. Well, I don't see how prosecutorial immunity applies to that situation. I'd have to take a look at the briefing on it, which I mean I can't really do. I don't. It would require a lot of time to. Because I'd have to look at your complaint to see how you pled it. Then I'd have to look at your, their briefing to see exactly how they're attacking it. And
The
if,
complaint's 95 pages long.
yeah, see, I can't do that. I can't do that. But I can tell you one thing: if your complaint is 95 pages long, there's a high probability that you're going to get. You're going to get ordered to trim that down.
I've been working on it. It's hard to
Yeah.
do that. There's just so much. They did so much, and it's hard to.
Yeah. Have you looked at the PowerPoint from the Arizona class?
Yes, I've watched that multiple times.
Okay. Yeah, because that's look at some of those cases because that'll help you kind of develop an instinct about what facts are necessary and what facts are not.
Right.
Because there's probably with 95 pages, I can almost guarantee you there's a lot of unnecessary detail in there.
Yeah, there probably is, but I'm not an attorney, so I don't know. And I wish, that's what they complain about. That's what I told them too. I'm just as frustrated as you guys are. I don't want to do this.
Yeah.
How many pages should it be?
Well, there's really no rule of thumb. I mean, I have complaints outstanding right now that are 95 pages. But, it depends on the complexity of the case, really. So that's really the only answer I can give you. I have complaints also like this dead kid case, but that's 40 pages.
I think she's.
So, and then I have other complaints I have one complaint, it's a warrantless seizure case. I think it's only like 18 pages. So it really...
What's the average good to aim for?
I can't really give you a number. What I would say is what's good to aim for is the minimum that you feel is necessary to, at minimum, meet each of the elements of your claim.
Okay.
So if you see a fact in there that does not go directly to supporting one of your claims, get rid of the fact.
Okay.
Yeah. Sometimes that's hard. I mean, I even struggle with that. So, just keep in mind, and for you guys, I mean, I've written hundreds of complaints, and I still struggle with it. For you guys, you've written, maybe one or maybe the same complaint over 3 or 4 times, and just recognize that the fact that you're here, even trying, is a big fucking deal. Most people don't do it, so kudos to you for trying. And just keep working at it, man. It's a learning process all the way through. Every single time, you learn something new. So just
A question.
Yeah.
Can I take the bar exam without going to school? Because I think I could pass it.
Well,
I'm probably going to be able to pass it after this.
you have to look at your particular state law. In California, they have a law understudy program that they approve. The state approves, where you can study under an attorney's tutelage for 4 years. You have to, every quarter, you have to submit a fee. It's like $160 and some written essays, some graded work, just to show that you're doing it. and then you can qualify to sit for the California bar exam. You don't get a degree, you won't have, like a JD or LLM or anything like that, but you can basically read the law and get a license. I don't know if Montana does that or not. You got to look at your local, your state's rules. But I have a guy right now that's doing that with me. He's doing.
I'm doing that.
Yeah. See, I knew a lady that I went to Jerry Spence Trial Lawyer College back in 2011, and one of the other students there, she did that. And she's been practicing now, I guess, 20-something years, no problem. So yes, it's possible. It just depends on your state rules. So anybody else? Any questions? Any comments?
Just one. Oh, go ahead.
You can go ahead.
Have you ever had an instance where transcripts were not provided to an appellate attorney and they file a motion to have them, because I've read that only one of them where they had to go to the appeals court where they made them furnish the transcripts, because I'm waiting for my transcripts to go to the appellate lawyer. The first request for extension was done and approved at the same time, and the second one has yet to be acknowledged. And I was just curious, what happens if they don't provide the transcripts? From what I'm reading, the appellate lawyer still has to, find a way to appeal the decision, even without that information, which I feel is like the bulk of what he would need to, contest it. How else would one, argue a judge's ruling without knowing what?
Well,
went on?
you need the transcripts if the clerk's transcript does not have sufficient information in it, to challenge the appeal. Because unless you're looking at a de novo issue on appeal, then you always have the burden, actually. The appellant always has the burden to demonstrate prejudicial error, regardless of whether it's de novo or abuse of discretion or whatever, substantial evidence, whatever the standard may be. So it's always the appellant's burden to show prejudicial error. It starts getting, kind of tough to meet that burden if large swaths of the record, which would include, the court transcripts, are missing. So, there's a process to get those ordered produced. First you're going to designate them in the normal, designation process. If the court reporter or the trial court refuses to produce them, then I think you're going to have to make an application to the Court of Appeals to get, number one, more time, and number two, an order directing that the transcripts be produced.
Why wouldn't they produce them? Why did they make you jumping through so many hoops just to be dicks?
That's what I couldn't understand. Why would you not?
Is it Los Angeles? Where are you?
Cocoa County, Northern California, Costa County.
If it was LA, I would have said that LA is notoriously slow on getting anything out of the juvie court, even for appellate records. But up there, I don't know, customarily what they do. What you might do is Contra Costa County, you're right across the bay from Bob Powell. If you know him, you might just call him up and ask him. Ask him, what he thinks you ought to do. Or if there's a process, he may have some insight.
Will do.
Yeah, that's probably worthwhile. But yeah, that's the way I would normally do it. There's a practice guide. You can probably, get access to it at your local law library. It's done by Thompson West. It's called Civil Trials and Evidence. No, wrong one. Sorry. Civil Writs and Appeals. California Civil Writs and Appeals. You might go take a look at the practice guide and see what they suggest for your circumstance. It's usually pretty good. It's like a cookbook for attorneys. I've got their full sets here, and I regularly use it. It's like a Bible, man. When I come across something new, I don't really know what's going on. You just go look up that section in the practice guide. It'll give you a really, really good 10,000 foot view, and maybe even depending if it's a common issue, they get much more granular and give some pretty good practice tips.
Who is that by?
It's Thompson West is the publisher, and they have a whole series. There's Rudder Guide Civil Trial and Evidence. There's Rudder Guide Civil Procedure Before Trial. There's then the Rudder Guide Civil Writs and Appeals, and they have both the state and the federal version because the rules are different in each venue. But that's well worth looking at if you're sort of getting stumped by a legal question like your transcript issue. First place I'd look would be the Civil Writs and Appeals, the practice guide.
Thank you.
Sure. So Marissa, you had a question?
Yeah, my question is kind of for Mike to kind of help him out. I know with him, he's been having a hard time getting his reports, considering where the stage is. And I feel like that'd be a really difficult component not to have when trying to put together the complaint. How do you know any ways to access old records when the case is already at a point where he's not able to access them without the judge and still waiting for the appeals process to go ahead and release those records?
I'm not sure I understand your question. Are you asking whether or not he can file an 827 petition while his record designation is pending?
Yes. Maybe not. That's
Basically, what she's saying is if I'm not entitled to anything at this stage of the case, my previous lawyer is no longer the one representing me, so he has no authority to request access to confidential records, and I don't have an appellate lawyer assigned yet because they haven't sent over
Right.
transcripts later to
File an
designate my.
File an 827 petition. Well, normally, as a party to the case, you shouldn't actually have to file
That's
anything.
what I thought. If you were, party to the case, you should have
Yeah.
a right to your own record.
Right, but none of the counties follow that rule. They all make you file an 827 petition. So
Aren't you there?
that would be my approach. Is I would just file an 827 petition and go from there.
Thank you.
But at some point, once your designated records get produced, you should have, the full unredacted record as part of your
Mhm.
clerk's transcript.
Mhm.
But that won't include internal agency documents. That will only include the contents of the court file.
It will have all of the dialogue from all of the requested court hearing dates, correct?
It'll only have whatever got filed in the court file or reporters' transcripts if there were court reporters.
There was.
It won't have any of the internal agency documents like the contact
Yeah.
notes, the structured decision-making tools, the investigation
Right.
narratives, all that crap. Yeah.
You have to have a judge's approval to get access to that, and then what level of access you'll be permitted, even if given, correct?
Right. That's what you would file the 827 petition for, is to just get access to everything. And then you'll have a hearing on it, and the judge will make a decision. And just remember, whatever decision they make, it's always without prejudice to you coming back again later if you think you need more. So it's not like a one and done type deal.
I'll be able to request then for them to unredact the person that called in and made the complaint. Is that possible?
That might get a little bit tricky. I don't know about Montana. Remember, the rules on accessing juvenile records, they're particularized by state. It's not an overarching federal rule. So every state's going to be a little bit different on accessing the records. But with that being said, in California, via the 827 process, it is very, very difficult to get the state court judge on board with the idea of disclosing reporting parties. The same is not true in the federal district courts. Remember, the federal district courts have concurrent jurisdiction with the state courts to decide the record production, record confidentiality issues. So what we've found is that your prospects of getting further unredacted information are better if you do it via the discovery process in your federal civil rights action. So that's just the way we do it here. That's not necessarily the right way or the wrong way. It's just how we do it. I know other attorneys do it differently, and you just got to do what works.
And when would I want to request that? It be sooner rather than later, or because I feel like it would be beneficial to know who that was, considering the caseworker and the violation of my confidentiality. And then in her affidavit, when they state like comments that the caller had made. Mm-hmm. Found out that those were comments made from the case that my ex-husband had filed just in retaliation for make a report. And that was it was not substantiated. They didn't open a case, nothing. That was a comment from that occasion and not from the time in question. And I believe in my mind, I'm thinking, well, what if it was this girl and the caseworker and they just conjured up an idea to just do it just to evil.
So if
that would change things.
Well,
if we knew that was the case.
If you just filed your lawsuit and you haven't yet gone through the motion to dismiss phase, then unless the judge has ordered otherwise, either in their standing order, an order in your case, a scheduling order, or something like that, your discovery is basically on hold until you're released to do discovery. So probably you aren't going to be able to, and I don't know, you're going to have to look at your local rules and your courtroom rules to see what your judge does. But I can tell you here in the Southern District of California, there is a discovery hold on all discovery until the scheduling conference. And the scheduling conference is not going to happen until all the motions to dismiss are resolved. So that's, the fundamental problem. So I'm not sure really what the answer would be in your area, but I would think that your best prospect of getting the information at the moment, if your discovery is stayed in your federal proceeding, is to file whatever your state requires that would be analogous to our 827 petition. And that's going to be driven by state law. I don't know what Montana does there.
And then wait until after my motion to dismiss is done first, right?
Right. Well, the court will let you know when your discovery is open, and once discovery is open, then you just ask. You just ask them to produce unredacted documents. They'll say no, and then you'll file a motion to compel in your federal district court. So anybody got, oh, you know what? One thing, Mike, I meant to ask you, how is your complaint writing going with the augmentation with ChatGPT?
It's going good. I'm running it all through Grammarly too to get some kind of statistics. Like for example, my argument, if read, is just shy of 20 minutes. So I was thinking, even if it was 5 o'clock on a Friday, with the holiday weekend approaching, 19 minutes and some change should be enough time to get my point across. So I'm trying to make sure that I can keep it under, we'll say 25 minutes. I think would be safe because I feel like I'm about halfway through. Maybe
Hey,
three-quarters.
hold on 1 second. Somebody's got music or something playing in the background.
It's my phone. Sorry.
Can you? Yeah, there you go. Just mute it. Go ahead, Mike. Sorry.
So I figure, under 25 minutes should be safe with enough information, but not too much, and should catch any particular individual who's reading it, with enough mental time to, get through it. And I think the chapter thing, will be a good component for myself. Not to mention if you choose, your headers, your chapter headers,
Right.
strategically, those that in itself should continue to keep your reader engaged and, force them to want to read on because, with such, headers that, are so drawing in, you'll be like, oh man, I got to know what happened next. So that's what I'm going to do.
Another benefit. Another benefit of the little chapter headings is that if you put them together correctly, if somebody's in a rush and they just want to get the gist of what your story is, they should be able to just read your section headings and say, oh, okay, I know what this story's about. Right? Now, obviously, the details are going to be, in the pleading itself, but if you have, well put together, well thought out chapter headings, I can skim through it pretty quick and know exactly what you're going after in your claim for relief, and you sort of want that.
Yeah, because my chapter headings at this point are just the date of the and type of memo that was issued out, which is super probably boring and dry. But if I can summarize it in 5 or 6 words of what actually transpired in that memo that made it so egregious and offensive,
right?
They'll want to read it, and again, still keeping it systematically and timely in chronological order at the same time.
Right. Well, that's a good way to approach it. I'm interested to see what that looks like once you've got the whole thing put together. I'm especially curious to see, what, if any, difference the use of the technology made.
More than likely, you'll be like, man, I feel like I wrote this because a lot of it is, sourced from you, but running it through all of these, different platforms, it's making it basically sharpening it up, on many different levels, grammatical, type of story, what your audience is that's going to be reading it. So I'm tweaking that in order to have it format and kind of reword what you already said to target certain things.
Yeah, I'm excited to see what that looks like. I'm excited to see the product that comes out of that. That should be interesting. Well, you guys, I got to get ready for the live stream tonight. James has me set up doing the live at 6:30 since I wasn't around to do it last night. So unless there's any other burning questions or comments or something, I'd like to cut it off so I can go get some food and take a little break before getting on the stream.
Last question. You said negligence consisted of 4 things: duty, breach, what were the other two?
Yeah. Causation, and damages.
Thank you.
Yeah, and that's one place you can go look for that, and it's readily available online. It'll have the elements essentially of every state law claim that you're ever going to want to pursue. Is the California jury instructions, the CACI jury instructions, and they're available on the Judicial Council website.
Thank you.
Yeah.
Sorry, whoever I cut off.
The Judicial Council is the ones that you complain to about your judge, correct?
Well, that's one of their functions, yeah. But they do a lot of other things as well.
I told you that I got the judge investigated, and it looks like they're going to ask him to retire early.
No, I don't remember that.
Yeah, the judge in my family law case is in pretty big trouble, but the board or count committee or whatever called me and told me that they were going to move forward with corrective action.
Oh, that's cool.
Yeah, and then what Mike was saying about his chapter headings and stuff, that's kind of how I wrote one of my books. Mm-hmm. So when you open up the first page, you can see kind of where the story goes, and I just thought it was pretty cool that he was doing the way he was doing his
cool.
Reading. So cool,
right on, man. So unless anybody else has any questions, let's go ahead and call it.
I was just gonna say thank you.
Thank you.
Thank you guys. Thanks for coming. I think it's cool. We got 5 people here, so that's nice. So just so that everybody knows, we do record these and we go ahead and publish them on YouTube for the people that were not able to be present or couldn't figure out how to get here. So always keep that in mind when you're joining in here, is that it is recorded and it will be made public.
Are you supposed to tell people that at the beginning of the conversation?
Well, I mean, obviously there's no expectation of privacy because you're all here with 5 strangers. But yeah, we generally have been telling people that both on YouTube and Patreon, and then also you can see on YouTube that we publish them. They're all there, so just keep that in mind. All right,
Okay, thank you.
you guys have a wonderful evening. Thanks for coming.
I.
Bye bye. Hey, so
Oh,
anyway, I'll be on the live tonight in about 20 minutes.
sounds good. Catch you on there.
All right, sounds good. Thanks.
Bye.
Bye.